I've explained to you that you face a sentence on count 1 of either life in prison with your first possibility of parole after 15 years, or life in prison without the possibility of parole. After consideration of this case and the other counts that you face and the recommendation of the state, I am going to follow on that count the state's recommendation based on, the facts and circumstances I'm required to consider, and consideration of all my relevant sentencing factors. I have considered the arguments of counsel. I've considered the victim impact statement. I've considered the facts that you have accepted responsibility for, and the horrible, horrible circumstances that bring us here. And I'm really not one to belabor conversation with someone who's going to prison for that long. There's not much that you need to hear from me. But I think you understand how devastating it is, the conduct that you have committed. And so the minimum sanction that will protect the public and punish you, considering all factors and the burden on state and local resources, after analyzing all the factors I have to consider, including, as Attorney Hall indicated, the seriousness factors, which involve not just, but include the age of this victim. But I am going to impose upon you for count 1 a term of life in prison with your first possibility for parole after 15 years. You now have 5 separate counts to be sentenced on for felonious assault. Each of those counts are separate and distinct offenses. You pled to circumstances from the indictment of a course of conduct over a period of time that resulted in different injuries to this baby. And those counts do not merge, and the state agrees with that, and Attorney Parker, your lawyer, agrees with that. That's true, counsel?
Yes, Your Honor.
Yes, sir. So each of those receive a different sentence. And I have to tell you that when someone accepts responsibility, the court takes that into consideration when I'm trying to decide whether to give someone the maximum, right? You accept the responsibility, you haven't belabored the point, you have acknowledged your wrongdoing. And in part, that is why I did not choose to impose life without the possibility of parole from count 1. However, as it relates to counts 2 through 6, you face anywhere from 2 to 8 years as a minimum, and you face anywhere from 2 to 12 years as a maximum on each count, which can be run consecutive. And I think because of the grievous nature of this offense and all the factors I'm required to consider, that for each count, beginning with count 2, felonious assault to felon in the second degree, I am hereby imposing upon you a minimum of 8 years, a maximum of 12. And as you know, that is the maximum minimum sentence you could get, right? The minimum term is anywhere from 2 to 8 years, and I'm giving you 8. And I'm giving you a minimum term of 8 on each of counts 2, 3, 4, 5, and 6. And that's important for you to know. Although you only receive, as it relates to those offenses, 1 maximum, it's important for you to know that each minimum will apply, because I have determined that consecutive sentences are necessary to protect the public from future crime and to punish you. I do not think, despite that there are 5 counts, I do not think that consecutive sentences are disproportionate to the seriousness of your conduct. Stated in layperson's terms, I think that the conduct is so terrible that 1 single sentence would not suffice, and that it's not disproportionate to the danger that you pose to the public for inflicting this kind of harm on someone who is completely vulnerable and defenseless. I will tell you that I think that these offenses, at frankly counts 1 through 6 combined, the rape and each of the 5 felonious assaults, were committed as part of 1 or more courses of conduct, and that the harm that was caused by you was so great, was so unusual, that again, no single prison term for any of those offenses adequately would reflect the seriousness of your conduct. And so what that means, sir, is that on counts 2 through 6, the minimum aggregate that you would do is 40 years. And the maximum is 44, because you only get 1 maximum. And I'm running it consecutive for the reasons I explained to you, to the life sentence with your first possibility for parole after 15 years. So what that means is that you first serve this 40 to 44. and then serve your life sentence will begin. The state and your attorney and I have discussed whether your indefinite portion will even ever kick in. If you finish the 40, you just go right into your beginning of your life sentence. And that is up to OERC. Technically, a sentence on indefinite sentences with a minimum and a maximum term require that you behave a certain way in the institution to avoid the maximum, and I've talked to you about that. The sentences that you have on these cases, though, are combined with a life sentence for rape, and that is a mandatory sentence. That is a sentence for which you will serve that time, and for which your behavior may depend, parole may depend on your behavior, but you will certainly serve that entire portion of that sentence. So I say that to you so that you understand that you may serve those first 40 years and behave very poorly, or not, but your life sentence is going to kick in after that. Does that make sense to you, sir? It's not run at the same time. I want to make sure you understand, Mr. Santos, that technically on these felonious assault offenses, there is PRC, is post-release control. That means that if you were only serving a felonious assault, you would be required then to, upon release from prison, be subject to the adult parole authority for PRC for at least 18 months up to 3 years. When we've talked about PRC, what do we that's when someone is subject to that supervision for that period of time, determined by the adult parole authority, and they're in charge of your behavior, and violations can result in being sent back to prison, anywhere from 9 months for each violation, up to half your stated prison term for the total of your violations. However, in this case, you're then going to begin a life sentence on rape, and PRC does not apply. That is a parole designation, and so parole will decide when you're able to be released after your first eligibility, which, as you know, as I've explained to you, is 15 years after you serve the consecutive sentences for the felonious assault. You understand that? It doesn't mean that you'll be released then. That's when parole will make that determination. That's when you're first eligible. Does that make sense? I know that's a hefty sentence, and I know that you may have questions, and so I'm here to answer those questions if you have them. You are legally entitled to any jail time credit for having been in the county, and that will be calculated and added to the journal entry in the case. That will especially aggregate towards the 40 to 44 sentence that you've received on the felonious assault offenses that have been run consecutive to each other and to the rape at count 1. I do not believe Mr. Santos has the present or future ability to pay any financial obligations, costs, fine, and so the court is waiving those. And I have explained to Mr. Santos his Tier 3 sexual registration. Is there anything that the state wants the court to address that the court has failed to address at this time?
No, Your Honor, thank you.
Anything from you, Attorney Parker?
No.
The last thing I think it's important to mention, Mr. Santos, is that this is a final appealable order, although certainly you have limited your rights on appeal by accepting responsibility for the consequences and pleading guilty. But if you wanted to appeal, once the injury's out, you have 30 days to do that, and the court can appoint a lawyer for you. And that's important for me to make sure you understand. The other thing that I think is important for you to understand, Mr. Santos, is that I have been told that you are on the witness list for the trial that will begin this afternoon. Certainly, you will not be testifying today. We'll be taking a jury today. Testimony will proceed throughout the week. You will have to talk to Attorney Parker, who will be available to you. I have been advised that you are considering pleading the fifth. I want to explain to you that you have been sentenced and you have pled guilty, and the Fifth Amendment may not apply to your testimony. And that's important for you to understand. So Attorney Parker has been advised to that by the court in a conference with the prosecutor and with me, and he's going to talk to you about that. And I want to make sure that we're on the same page. And then we will convene about that again outside the presence of any jury before trial, before Mr. Sanchez will testify. Is there anything the parties have to address on that point? Attorney Hall?
No, not this time.
Attorney Parker? Mr. Sanchez, anything that